In this video, we're going to take a look at the Unfair Contract Terms Directive from 1993. Article 1 of that directive indicates for us what its purpose is, and it tells us that the directive aims to approximate the laws, regulations and administrative provisions of the member states relating to unfair terms in contracts concluded between a seller or supplier and a consumer. So we already see that this is a directive aimed at consumer protection. It relates to contracts between businesses and consumers. To determine whether or not a contract term or a contract falls within the scope of the directive, it therefore becomes necessary to look at the definitions of what is considered or who is considered to be a seller or supplier on the one hand, and on the other hand, who falls under the category of consumers. For that purpose, we need to take a look at Article 2, which provides us with a number of definitions. So Article 2, paragraph B, tells us that a consumer means any natural person who, in contracts covered by this directive, is acting for the purposes which are outside his trade, business, or profession. A seller or supplier, on the other hand, is further defined in paragraph C of Article 2, and it tells us that a seller or supplier means any natural or legal person who, in contracts covered by this directive, is acting for purposes relating to his trade, business, or profession, whether publicly owned or privately owned. So that tells us a little about the personal scope of the directive, about which parties are involved in contracts that fall under the scope of the directive. The directive also tells us that it is about, or Article 1 of the directive also tells us that the directive concerned unfair terms. And Article 2, paragraph A of the directive further tells us that for the purposes of this directive, unfair terms means those contractual terms defined by Article 3. Article 3, paragraph 1 further limits the scope of the directive with respect to the test concerning unfair contract terms. It tells us that we are going to look in the context of this directive at the fairness of terms that have not been individually negotiated. So in the case of individually negotiated terms, they fall outside of the assessment of fairness that is laid down in the Unfair Contract Terms Directive. The question that then arises is, what is a not individually negotiated term? And here we can look further at Article 3, paragraph 2, which tells us that a term shall always be regarded as not individually negotiated where it has been drafted in advance and the consumer has therefore not been able to influence the substance of the term. And this is particularly the case in the context of pre-formulated standard contracts. So where the supplier or seller has drafted the terms in advance of the conclusion of the contract, and the consumer has been unable to influence the substance of those terms, then we are dealing with a not individually negotiated term, which could then be subject to the unfairness test in Article 3, paragraph 1. This is often the case when we are dealing with standard form contracts or general conditions. And if you think about the types of contracts that we frequently conclude online, where we have the small box at the bottom that says, I have read and I agree to the terms and conditions, and the only option that we have is to tick the box or not to contract at all, then that clearly falls within the scope of not individually negotiated terms. So when is a contract term to be regarded as unfair? Well, we find the test for unfairness in Article 3, paragraph 1. And it tells us that a contractual term which has not been individually negotiated shall be regarded as unfair if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract to the detriment of the consumer. So if we take this test and try to take it apart, we see that there are 3 steps that we essentially need to follow. Firstly, we need to assess whether or not the term causes a significant imbalance in the rights and obligations arising under the contract. So that's the threshold. Is there a significant imbalance? Not just an imbalance between the rights and obligations, but a significant imbalance between the rights and obligations of the parties under the contract. The second step we then need to establish is whether that significant imbalance is to the detriment of the consumer. And thirdly, having established that there is a significant imbalance, that it's to the detriment of the consumer, it furthermore needs to be assessed whether or not that detriment to the consumer is contrary to good faith. So introducing the concept of good faith into the directive means that we have an open-ended norm that is used in order to assess the fairness of the term. And in order to provide us with some more guidance, we see that in the annex to the directive, there is a long list of contract terms which may be regarded as unfair. Now, Article 3, Paragraph 3 tells us that this annex is to be regarded as an indicative and non-exhaustive list of terms which may be regarded as unfair. So it doesn't mean that these are the only types of terms that could be treated as unfair or that could fall under the assessment of fairness within the directive. It's simply giving an indication of the types of terms which may be regarded as being unfair. Now, it doesn't say in the directive that if the term falls on this list in the annex, that it is unfair, that it shall be regarded as unfair. We note the word may, which means that there is still a possibility for assessment and evaluation. Article 4, Paragraph 1 provides us then with some further guidance on how to make the assessment of unfairness in light of the test laid down in Article 3, Paragraph 1. And Article 4, Paragraph 1 tells us that the unfairness of the contractual term shall be assessed taking into account the nature of the goods and the services for which the contract was concluded, and by referring to all the circumstances at the time of the conclusion of the contract which attended the conclusion of the contract, and to all the other terms of the contract or any contract on which this particular contract is dependent. So what we see here is that we have to take a more holistic approach and look at the contract term in light of the contract as a whole and the relevant circumstances that relate to the conclusion of the contract. We cannot just simply look at a term in isolation and determine whether that particular term is to be considered as unfair. We have to look at it in a broader context. Article 4, Paragraph 2 also tells us that when assessing the unfair nature of the terms, we should not be looking at the definition of the main subject matter of the contract. So we're not looking at the core of the contract as to what the contract is about in respect of the main subject matter to which it relates. And nor should we be looking at the price or the remuneration to determine whether or not that is fair, because that is an assessment that essentially falls outside the purview of the courts. So if a contract term has been found to be unfair in accordance with Article 3, Paragraph 1 of the Directive, what is the consequence? Well, here we look at Article 6 of the Directive, and it tells us that a term that is unfair is not binding on the consumer. And it means that the contract itself will remain binding, provided that it can continue to exist without the unfair term, but the unfair term will then no longer form a part of the contract and the consumer will not be bound by it. The directive also contains a provision on the use of language in contract terms. So in Article 5, it tells us that when contract terms are put in writing, they need to be in plain, intelligible language. And Article 5 furthermore lays down a rule of interpretation, a rule that we generally know as the contra proferentum rule. Now, according to the contra proferentum rule, where there is doubt about the meaning to be attached to the words used in a contract term, the interpretation that needs to be favored is the one that favors the party who was not responsible for drafting the terms. So in terms of the directive, it tells us that where there is doubt about the meaning of a term, the interpretation most favorable to the consumer shall prevail. In essence, this contra proferentum rule places the burden of formulating the contract clearly on the party who is the one who is drafting the contract. And if there is any ambiguity in respect to the meaning to be attached to the contract terms, that ambiguity is to be resolved in favor of the person who was not responsible for its drafting. This directive on unfair contract terms is a directive that that has a minimum level of harmonization, and we see that in Article 8. Article 8 tells us that the member states may adopt or retain more stringent provisions to ensure a maximum degree of protection for the consumer. So if we were to contrast this, for instance, with the Consumer Rights Directive, which has a maximum level of harmonization and which does not allow member states to go above the level of harmonization provided in that directive, we see that this earlier directive from 1993 is one of minimum harmonization. So the member states are obligated to implement this directive into their national legislation. They are obligated to provide at least this level of protection to consumers when it comes to unfair contract terms. However, they may go over and above the protection that is offered by this directive in their national legislation. And to give an example of a country that, or a member state that has gone above the level of harmonization that is laid down in this directive, we can take a look at the Netherlands. And in the Netherlands, the legislator has chosen to create two lists of terms that can be regarded as unfair. And now the distinguishing factor between these two lists is that one list we refer to as a grey list and the other list we refer to as a black list. Now, terms that are on the black list are always regarded as being unfair, whereas terms that are regarded as that are on the grey list, there is a presumption that these terms are unfair. However, it is still possible for the seller or supplier to establish that given the circumstances, they do not fall within the unfairness test and should remain binding on the consumer. So here we see that the Dutch legislator has gone a step further than what the directive has done. The directive in its annex gives some indications of what could be regarded as unfair, but they still remain subject to the general fairness test that we see in Article 3, Paragraph 1. The Dutch legislator, on the other hand, has chosen to identify a number of terms that will always be regarded as unfair in a contract, and thereby it raises the level of protection for consumers.